Welcome to Seacoast Real Estate Academy. In today's video, we'll cover all key terms found in Unit 10. Acceptance. Expression of intent by the offeree to be bound by the terms of the offer. Must be in writing if the contract pertains to real property. Acceptance must be communicated to the opposite party to create a contract. Backup offer. An offer submitted to the property owner with knowledge that the owner is already under contract. A secondary offer. Contingency. A provision in a contract that requires a certain act to be done or a certain event to occur before the contract becomes binding. A condition of the contract. Due diligence. A buyer's investigative process of having experts inspect the property, examine title, and review any leases to determine if the property meets the buyer's needs and if the buyer wishes to proceed with the purchase. During the due diligence period, the buyer can terminate the purchase contract for any reason or no reason. Installment land contract. A contract for the sale of real estate financed by the seller whereby the purchase price is paid in periodic installments by the purchaser, who is in possession of the property even though legal title is retained by the seller until a future date, which may not be until final payment. Also called a contract for deed or land contract. Mailbox rule. A rule of law stating that once written acceptance is placed in control of the mailing service and out of the control of the offeree, it is considered accepted, not when the acceptance is actually received by the offeror. NCBA, NCAR 2T Offer to Purchase and Contract, OTP. A form often used by realtor or licensees and/or North Carolina attorneys to establish a legally binding agreement between the buyer and seller concerning the terms of purchase or transfer of residential real property. Option. An agreement between the property owner, the optionor, and the possible buyer, optionee, secured by the payment of an option fee to buy or not buy property within a specific time period at terms that have been negotiated in the underlying contract, also called option to purchase or option contract. Optionee. The possible buyer in an option contract. Optionor. The property owner in an option contract. Preemptive right. A provision giving a person the first right to purchase real property, most often found in commercial leases. Right of first opportunity to purchase. The right of a party to have the first opportunity to purchase or lease real estate for a designated price, if the owner ever decides to sell or lease. If the holder of the right does not opt to purchase, the owner may sell to a third party within the specified time. If sale to third party does not occur, the right is still valid and process restarted. Right of first refusal. The right of a person to have the first opportunity to either purchase or lease real property, if the owner ever decides to sell or lease. No terms are negotiated. Uniform Electronic Transaction Act, UETA. North Carolina version of the federal e-sign legislation that validates electronic contracts, documents, and signatures. If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.